In a 5-3 decision Thursday, the court sided with Hamdan. The case was argued on March 28th and is about 90 minutes.
We'll hear argument in number 05184, Hamdan against Rumsfeld. Mr. Cadiel, you may proceed.
Justice Stevens, and may it please the Court, we ask this Court to preserve the status quo, to require that the President respect time-honored limitations on military commissions. These limits, placed in Articles 21 and 36 of the Uniform Code of Military Justice, require no more than that the President try offenses that are indeed war crimes and to conduct trials according to the minimal procedural requirements of the UCMJ and the laws of war themselves. These limits do not represent any change in the way military commissions have historically operated. Rather, they reflect Congress's authority under the Define and Punish Clause to codify limits on commissions, limits that this Court has historically enforced to avoid presidential blank checks. And because this commission transgresses those limits, it should be struck down and the district court order reinstated. If I could turn to the jurisdictional matter for a few moments first. We believe that the DTA, while certainly not a model of clarity, does not divest this court of jurisdiction for four essential reasons. The first is that if I could turn to the surreply at the appendix of page 14A, that contains the initial version of the bill that passed the Senate on November 10th. And at 14A it says, on the effective date provision, the amendment made by paragraph 1, which is the jurisdiction stripping provision, shall apply to any application or other action that is pending on or after the date of enactment of this Act. That language clearly attempted to strip courts of jurisdiction over Guantanamo claims. That language, however, was changed in the final version of the DTA, and the final version of the DTA is found at page 10A of the surreply. And that has the following as its effective date. It has two effective date provisions. The first one I want to start with is H2, Review of Combatant Status Tribunal, CSRT, and Military Commission Decisions. Paragraphs 2 and 3 of subsection E shall apply with respect to any claim whose review is governed by one of such paragraphs and that is pending on or after the date of enactment of the Act. And then there is a separate provision for the rest of the DTA.
Where was that change made from the prior version?
The change was made between November 10th and November 15th.
Yeah, I mean, it was made in what House? Was it made by the Conference Committee?
It was made in the Senate.
It was made in the Senate. So the House presumably never saw the prior language.
That's
and
correct.
The President who signed this bill never saw the prior language.
That is correct.
So why should we attribute to both the House and to the President a knowledge of the prior version of the legislation?
Well, because the language itself was, I think, the subject of an immense amount of debate. And indeed, when the language was
in the Senate.
In the Senate, and well known, and indeed attribute any knowledge to the President, we have evidence in the record that the administration tried to change the language back to the original formulation. And indeed, in the House, the chairman, one of the vice chairman of the conference report said that the change in the language the change in the language meant that it grandfathered pending cases such as this one. So this is not an example of which we have to resort simply to the negative inference of Lind. However, we do think that is the second reason for you to believe that this case is grandfathered under the existing DTA.
But in addition to this case, I mean, this case is pending in the U.S. Supreme Court. There are many cases pending in the district court when this law comes into effect. What about those cases?
We believe that, as the co-sponsors said on November 15th when they introduced the final version of the language, that all of those cases are grandfathered with respect to the H1 effective date provision and the E1 jurisdiction stripping provision. However, that still leaves in place the government's main argument in the D.C. Circuit below, which is that the E2 provision governing CSRT and final decisions and the H2 provision governing final decisions of CSRTs truncates all of the review that is currently in the D.C. Circuit. So it's certainly plausible, it's certainly possible, though it's not, of course, presented in this case, to read the DTA as truncating the vast majority of claims at Guantanamo in current pending cases. Of course, that isn't the issue before you here. The issue before you here is simply the Hamdan case, and there was a strong desire by the Congress not to interfere with this Court's traditionally exercised jurisdiction.
Please go over that again. I'm not sure I understood. I understood your response.
Okay.
You say that it could be read to preclude cases in the lower courts, but not here.
That's right. Cases in which there is a final CSRT decision, that is, that the government's argument in the D.C. Circuit, Justice Scalia, is that there are two different ways in which the DTA truncated the review of Guantanamo cases. One is the claim that the jurisdiction stripping provision applies to pending cases. That we reject. That we think the Senate rejected on November 15th when it passed the bill. The other is the claim that the E2 provision governing final decisions of CSRTs, which does, of course, apply to pending cases, as the plain text says, eliminates and truncates a vast majority of the detainees' claims. That is the provision.
Does that mean, in practical terms, that the other claims that are in the district court get transferred to the circuit? The circuit is bound by the limitations that you've just described, and at the end of the day, the complaining parties in those cases can raise the question whether Congress could properly have truncated them as it did, but it simply got to wait.
Absolutely. And to be clear, that's not the position we're saying that is the DTA. That's not presented here. That's the issue below in the D.C. Circuit. In addition, we believe that this statute doesn't fall within the Bruner-Hallowell presumption that the government seeks to use here for a few reasons. The first is this is not a statute that is merely divesting a lower court of jurisdiction. Rather, it's a statute that alters substantive rights of Mr. Hamdan. In particular, as the government itself says, it eliminates Question 2 upon which certiorari was granted, which is compliance with the Geneva Conventions. In addition, it alters entirely what both courts below found, which is that Mr. Hamdan has a pretrial right, a right analogous to Abney versus United States, to bring his claim now because he's challenging the jurisdiction of the tribunal. That pretrial right is something that that goes all the way back to the founding in the early cases that this court decided on pretrial habeas. In addition, we believe
why does it affect the scope of the review that he could get eventually? If there's a final decision, there can be review of whether the use of the standards or procedures that were used by the Commission to reach a final decision is consistent with the Constitution and laws of the United States. Why doesn't that encompass any claim that he might want to make later on?
Well, as the government says, it certainly does not encompass Question 2 because it eliminates the word treaties. It's a change from the habeas corpus statute. More generally, it doesn't do two things. First, if that's the reading that the government wants to give, then it essentially means that the President has the ability to block habeas corpus or post-DTA review for all time. Because, Justice Alito, it doesn't turn on — you can't walk into court right after you're convicted under the DTA. You can only walk into court after a final decision, and a final decision requires the sign-off of the President of the United States. And so effectively, this reading would give a litigant the ability to block federal court review for all time.